The challengers could not make this showing in the court's view because the Second Amendment does not protect the right to own dangerous and unusual weapons, including AR-15s. What? They said that you could possess the weapon? They placed the burden on the wrong party. Man, what a great full circle segue on this, right? The burden got shifted again to the wrong party. They said you could also have a ricin pellet firing umbrella gun, which also, I don't know if they had those back in the old days, but why not? Or even a W-54 nuclear warhead. Wow. The Supreme Court punts on the Second Amendment. In this case, David Snopes versus Anthony G. Brown, the Attorney General of Maryland, suing over the ban on a certain type of weapon that was imposed in Maryland. Now the Supreme Court had an opportunity to accept this case, resolve it, and they didn't. And we have some good dissents here. Now, what we're going to see, it was a pretty close decision on this. We have Kavanaugh, who's going to come out and kind of give us this waffly, like middle of the road thing. And then we're also going to see from Justice Clarence Thomas why this case should have been heard and heard now. Here is what we heard from the court. They wrote, "Now the petition for a writ of cert, which would have been filed by the people challenging the gun ban," right? There's a ban on the weapons. You want to get that ban eliminated. Supreme Court, can you get rid of that ban? They just said no. Now, Justice Alito and Gorsuch, they would have granted the petition. All right, so you got two over there. Clarence Thomas would have, Kavanaugh probably would have. Let's see what he says. Kavanaugh says, respecting the denial of cert, he says, all right, look, in the District of Columbia versus Heller case, which was that major Second Amendment case, this court ruled that the Second Amendment must be interpreted in light of constitutional text, history, and tradition, looking back to how things were interpreted during that time. And if the regulations on weapons were customary and normal at the time, then we could apply those here today. Now, the court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens, because handguns are in common use by law-abiding citizens, and the court held that the DC ban on handguns violated the Second Amendment as well. Because they're in common use, the ban violated the Second Amendment. Now, the court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. But this case primarily concerns the Maryland ban on the AR-15, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s, which is good, but not good enough. We need to double those numbers and pump those numbers up. So if you were looking for an excuse to go get one, go get one. The AR-15s are legal in 41 out of 50 states if it's legal, meaning that the states such as Maryland that prohibit AR-15s are something of an outlier, unless you're in Maryland. Now, given that millions of Americans own AR-15s, hopefully a lot more soon, and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected under the Second Amendment. And if that's the case, if so, then the Fourth Circuit would have erred by holding that Maryland's ban on the AR-15 complies with the Second Amendment. If they are in common use, then just like Heller, handguns are in common use, so a ban on those, illegal. Same thing applies. Now, under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15 at issue from the handguns in Heller. Yeah, AR-15s are semi-automatic, right? But so too are most handguns. Semi-automatic handguns and rifles are distinct from automatic firearms like the M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense, and for their part, criminals use both of them as well in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America, almost like handguns are worse. So in short, under this court's precedents, the Fourth Circuit's decision is questionable. Now, although the court today denies cert, a denial of cert does not mean that the court agrees with a lower court decision or that the issue is not worthy of review. Well, then why don't you just hear it then? The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals, giving us a bunch of the cases here. Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Now, additional petitions will likely be before this court shortly, and in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. Okay, so I guess he would have granted cert and heard the case, but doesn't really care about it right now. It's like, we'll hear it later, so just deal with it. Second Amendment people, you don't need an AR-15 in Maryland, okay? They're going to protect you there. Your government government cares about you in Maryland. So here you go. We got another dissent from Justice Thomas. Clarence Thomas dissenting. He says, court, the state of Maryland prohibits ownership of AR-15s, the most popular civilian rifle in America. Now, this petition presents the question whether this ban is consistent with the Second Amendment. The Fourth Circuit held that it is reasoning that AR-15s are not arms that are protected by the Second Amendment. Clarence Thomas says, I would grant cert to review this surprising conclusion. Clarence Thomas says the Second Amendment guarantees the right of the people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers his conduct. Now, once a challenger makes that showing, the Constitution presumptively protects his conduct, and the burden shifts back over to the government to demonstrate that its regulation is consistent with the historical tradition of firearm regulation. Now, if the government fails to make that showing, the restriction must be deemed unconstitutional. Now, it is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework, writes Clarence Thomas. He says, let's start here. First of all, AR-15s are clearly arms under the Second Amendment and the plain text. What are you talking about? It's not an arm. How can you say that? It says in DC versus Heller, we held that the term arms in this context covers this: all weapons of offense or armor of defense. That's what we said. Explaining that arms includes anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. That's what an arms is and arms are based on the prior context of history. Thus, the Second Amendment extends prima facie evidence to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Okay? If it's an arm that's something like used in offense, then it's automatically presumptively covered there. And you got to show why it's not. If you can't, your law is unconstitutional. AR-15 and the weapons like that fall squarely into that category. Now, because AR-15s are arms, the burden then goes back to Maryland. Yeah, it's an arm, so it's covered by the Second Amendment. So now you have to show why banning them, AR-15s, is consistent with this historical tradition of firearm regulation. But Clarence Thomas says, but I am not aware of any historical regulation that could serve as a proper analog to Maryland. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. And AR-15s, apparently, they say are both dangerous and unusual, is what they write. It's dangerous and unusual. Wow, very scary to them. And AR-15s appear to fit neatly in that category. Tens of millions of Americans actually own them, and the overwhelming majority of them do so for lawful purposes, including self-defense and target shooting. So a prohibition on an entire class of arms that is overwhelmingly chosen by the American society for lawful purposes is outside of the government power, and you cannot do that. Now, despite the foregoing, writes Clarence Thomas, the Fourth Circuit upheld Maryland's ban that AR-15s can be prohibited, saying they are not constitutionally protected arms. They are not arms. They said, well, at first blush, it may appear that AR-15s are arms. But the court said more is required. Because the Second Amendment must be interpreted against its historical and legal backdrop, whatever that means, the Fourth Circuit held that challengers also had to show the right to possess AR-15s fall within the historical scope of the right to keep and bear arms. What? The challengers could not make this showing in the court's view because the Second Amendment does not protect the right to own dangerous and unusual weapons, including AR-15s. What? They said that you could possess the weapon, you could keep and bear arms. The keep part doesn't mean ownership. Now, this reasoning is dubious at least twice over since Clarence Thomas. The Fourth Circuit placed too high a burden on the challengers to show that the Second Amendment presumptively protected their conduct, and in its determination that AR-15s are dangerous and unusual does not even withstand scrutiny. Thomas continues. He says, the Fourth Circuit erred by requiring the challengers who are contesting the law to prove that the Second Amendment protects their right to own AR-15s, right? So again, the burden shifted to them. Make them show that they're allowed to have the Second Amendment apply to them. It's not how that works. Or in the terms of our Second Amendment jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. Now, a challenger only needs to show that the plain text of the law covers him, and that's what they've done. Once the challengers show that, then the government gets the burden to show, actually, no, we do have a historical limit. They place the burden on the wrong party. Man, what a great full circle segue on this, right? The burden got shifted again to the wrong party, just like they tried to do in the Ninth Circuit, just like they tried to do with the elections. Now, our precedents make plain the error. In Bruin, we had little difficulty determining what the plain meaning of the Second Amendment is. We considered the historical limit limits on the right to bear arms to ask whether the state met its burden. Court did the same thing in Rahimi. Now, the Fourth Circuit based its opposite approach, its contrary approach, on an analogy to the free speech clause. But that analogy explains its error. The court reasoned that the historical evidence is necessary to prevent an overbroad understanding of the Second Amendment, just like the free speech clause excludes certain things like libel, incitement, true threats, and more. Now, as we explained, however, the government bears the burden of proving the constitutionality of the speech restrictions. That burden includes showing whether that conduct falls outside a category of protected speech by pointing to historical evidence about the First Amendment protections. They're like, yeah, it's the same thing. It's the same framework. Treating the Second Amendment like other constitutional provisions, we have similarly placed the burden on the government to show that a regulation of arms bearing conduct falls outside of the Second Amendment. Now, under the plain text of the Second Amendment, the challenger's only burden, the only thing that when you sue you have to do is show it was an arm. And here they are clearly. An AR-15 is an arm. And the Fourth Circuit separately erred in determining that AR-15 fall within the exception because they're dangerous and unusual. Weapons in common use today for self-defense are fully protected. The Fourth Circuit nevertheless eschewed any inquiry into the commonality of AR-15s. It just scares them. Just the word and just the sight of it, it just scares them. It could be a BB gun. It just, they'd freak out. Instead, the court performed its own independent investigation of AR-15s. They did an investigation into its utility for self-defense. They examined their military origin. They examined their firepower, and they examined its muzzle velocity. These judges, I'm sure they did, with the boom boom sticks that scare their pants off. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. We don't give a crap what your opinion is on muzzle velocity. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. You can only have a gun if it's not of military origin, if its firepower is reasonable, and if its muzzle velocity is not too fast, because we don't want it to go too fast and hit you. Says, in line with that principle, and with the tradition of prohibiting dangerous and unusual weapons, we have never relied on our own assessment on how useful an arm is for self-defense before we deemed it to be protected. Actually, what you're really going to want is some other ammunition that's directly for self-defense, and that's why you don't need more than 10 rounds. You can only need 8, but you can only have them if they have hydroshock ammos, which they would ban too. In Heller, we found handguns protected because of that class of arms. Americans get to decide which one is unusual. Stun guns were not unusual. In Bruin, we again found handguns were protected because they're in common use. Now, in response to the Fourth Circuit and their objection to common use inquiry, they said it would lead to absurd consequences. They said you could have a constitutional right to own a bazooka, which we should. They said you could also have a ricin pellet firing umbrella gun, which also, I don't know if they had those back in the old days, but why not? Or even a W-54 nuclear warhead. Wow. And I guess we could have SEAL Team 6 probably also too, launch those nuclear warheads when Trump takes over power and becomes the dictator for life after January 6th again. A W-54 nuclear warhead. Well, I think I could be pretty responsible with one of those personally. I mean, I wouldn't launch it against anybody, probably. What's up? So this reasoning illustrates why the scope of the right, these judges are ridiculous, obviously, right? Now, even if some nuclear warheads are small enough for an individual to carry, let's get into it. Okay, you want to talk about nuclear warheads? Weird judge? Clarence Thomas says, all right, fine. Yeah, let's do it. Even if some nuclear warheads are small enough for an individual to carry, no reasonable person would think to use one to defend himself. Putin might. Still less could nuclear warheads ever become a common means of self-defense. There it is. Not common. To fend off the fantastical threat of Americans lobbing nuclear warheads at one another. I don't know, man. I get pretty mad about that El Salvador case. I'll tell you what. The Fourth Circuit has allowed the very real threat of the government depriving Americans of the rifle that they most favor for protecting themselves and their families. Looking to the standards set by American society rather than our judicial colleagues, I cannot see how AR-15s fall outside of the Second Amendment's protection. And just to be clear, I wouldn't nuke, I would not launch a nuke. Although there is a pretty serious effort to, I think, nuke the moon, which could be interesting just to see what's going on over there. Here's what's happening. Says Clarence Thomas, I would not wait to decide whether the government can ban the most popular rifle in America. We don't need to wait Kavanaugh. We don't need to wait Amy Coney Barrett or Judge Roberts. Maybe that's what they're doing. The question is of critical importance importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade, getting tired of it. And further percolation on this is of little value, says Clarence, when lower courts in the jurisdictions that ban AR-15s appear bent on distorting the Second Amendment. I doubt we would sit idly by if lower courts were to so subvert our precedents involving any other constitutional right. He's right about that. No, in fact, they flip out if you don't respond to an ACLU demand in 14 hours. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. The constitutional status of AR-15s is all the more urgent after another decision in Bondi versus Vanderstock. Recently amended regulations of ATF provide that a firearm under the Gun Control Act includes objects that may be readily completed, assembled, restored, or otherwise converted to a working firearm. In Vanderstock, this court refused to hold that definition unlawful, reasoning that an artifact noun, that is, a word for a thing created by humans, may refer to unfinished objects, and thus that weapon parts kits are as regulable as the firearms they eventually may become. He says, but every single AR-15 can be converted to a machine gun using cheap, flimsy pieces of metal, including a coat hanger. So thus, on the court's logic, it seems that ATF could at any time declare AR-15s to be machine guns, prohibited by federal law, because you could just shove something in there. Now, until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is no constitutional guarantee at all, and so Clarence Thomas says, I respectfully dissent. Nice one from Clarence Thomas, man. And I didn't realize that this kind of issue has been percolating under their noses for 10 years. That makes Kavanaugh's sort of concurrence or dissent, whatever that was, as a mechanism of just allowing this to percolate even more ridiculous. So that's what SCOTUS did. The saving grace, obviously, is what Gun Owners of America flagged. It's Judge Kavanaugh saying additional petitions are going to come up soon and we'll handle it then. So maybe this is not the right case for them, but very nice dissent from Clarence Thomas. Second Amendment, second class right. And the Supreme Court they're busy right now, man. They've got too many deported illegal alien gangbangers to flip out about. All of them just waiting for the next ACLU class action lawsuit for Tren de Aragua and MS-13 to come in before they really get excited. But if you just want to enjoy the Second Amendment, well, in Maryland, not gonna happen, not anytime soon, because Supreme Court has more important things to worry about.